Hey folks, James Abrinio coming to you from Abrinio Law, your Northern Virginia personal injury and criminal defense law firm. In this video, I wanted to talk about an interesting development in Virginia law intended to protect victims of sexual assault, and particularly what the new law defines as vulnerable victims of sexual assault. So to help us understand this, I recently drafted an article for the Abrinio Law website. It's entitled "Virginia Recently Updates Its Laws to Protect Vulnerable Victims from Sexual Assault." By the time I update this website, I'm going to end up embedding this actual video into this location as well. So you'll see that instead of this picture. But what happened here is over the last few years, maybe 10 or so years, maybe even less, to be honest, there was a very interesting but also very concerning advancement of civil law here in Virginia and how the courts were reviewing cases brought by sexual assault victims when they brought suit against somebody that assaulted them sexually, but also the employer of that individual that assaulted that person in the course of whatever business the victim was in, whether it was going to a massage parlor for a massage, whether it was in a hospital being examined by a medical provider, whether it was the resident of assisted living. We were seeing cases where individuals are tragically sexually assaulted, sometimes violently, and the courts would say, sure, you can go after that individual defendant who likely doesn't have any money, but you can't go after the employer. And really what the courts ended up saying is because the employee, when they sexually assaulted that victim, did it for their own benefit and not to the benefit of the employer was essentially off the hook. And that was super concerning. So the Virginia General Assembly fortunately took action, and we'll get into the details of it here, but I'm glad to hear that our legislature stepped up and are attempting to close the gap. I also want to give some credit to an organization that I'm part of, Virginia Trial Lawyers Association. They put a real strong effort in advocating for this change. It wasn't me. I'm not taking credit for it, but a lot of great representatives of that organization put a lot of educational resources to the General Assembly to raise this issue. Unfortunately, there was a change. So let's talk about the court cases where this really became an issue. So what I've done in this article, you'll see, you can take some time to review it. I've here summarized two specific cases, which are the seminal cases leading for the law change. The first is Our Lady of Peace, and this is out of 2019. This is a Virginia Supreme Court case. And by the way, I've set this up to where when you click on it, it'll take you to the actual case PDF on Justia Law. And then the second case we'll talk about briefly is HC versus Potomac Hospital. This is a 2024 case out of the Virginia Court of Appeals. Again, you can click on that and then find the PDF. So just going back to Our Lady of Peace, this was a really, really, really tragic case. Horrific facts. So I just want to be clear about that. And when I'm talking about these facts, if you're somebody that just simply can't hear it, then I'd suggest you read the articles or turn off the channel, because unfortunately we'll get a bit of details of the facts of the case, and they're horrific. So that, with that being said, I'll go ahead and again focus on the case, and then we'll just talk about it. So this is the facts. There, a nursing assistant in a nursing home brutally and sexually assaulted an 85-year-old resident. At the time, the victim was, quote, weak, ill, partially paralyzed, and unable to cry out for help. Essentially, and then again, I summarized the facts and left out a bunch of them. But essentially, in that case, this assistant apparently was tasked with bathing and changing the resident, and during that bathing and changing, engaged in a full-on sexual assault, there were allegations of actual rape. So just again, tragic facts. And the reason he got caught was essentially another employee walked in and saw part of his activities, and then later he was investigated by law enforcement, and he ended up confessing, or making at least a partial confession. Now, the procedural posture of this case is a little bit weird because the victim actually won against the business, the nursing home here, and it was then appealed by the nursing home, and the Virginia Supreme Court ended up reversing, but in a way that was not the typical reversal where it says you got it wrong, the other side wins. Here the nursing home wins. Instead, it said, look, I think you need to take a closer look at the facts that you were presented. Now, why do I say that? So looking again at my summary, essentially when it came to whether or not, and the issue really is whether or not the employer here, the nursing home, was what we call vicariously liable for the actions of the employee. So here was the nursing home vicariously liable, meaning responsible financially for the sexual assault committed by its employee upon the nursing home resident, whom, again, the employee would not have had access to this individual but for his job, used his job in order to facilitate his behavior and ultimately give him the opportunity to commit this heinous act. There, the trial court essentially conducted what we call a directed verdict for the plaintiff. Essentially, the court said, look, the facts are pretty clear here that you, the defendant nursing home, lose because your employer was within the scope of employment, meaning he was acting to your benefit, therefore you are vicariously liable. And when I say scope of employment, that's really a technical term of art, meaning are you within the job description, or are you within the duties of your employment? Were you within the earshot or eye shot of what you're supposed to be doing there as an employee? And so what the nursing homes, what the defendants will do in these cases, is claim that the employees were not within their scope of employment. Therefore, the employer is not vicariously liable. They get off. Sure, you can get a judgment against that individual defendant, but if they've done this behavior, a lot of times they're in jail, which they should be. A lot of times they're not the kind of person that has a whole lot of money to compensate somebody for being viciously victimized. So oftentimes it's not going to be a whole lot of recourse to go after these individuals. So what the Supreme Court did once they got this case, Virginia Supreme Court reversed the trial court finding that there needed to be a detailed analysis as to whether an employer had motive to benefit the employer when he assaulted the victim. So they essentially, the Supreme Court said, trial court, you can't direct a verdict in favor of the plaintiff against the defendant nursing home without more facts being established. And the question we're going to be asking is not even just whether they're in the scope of employment, but a very specific analysis about whether the employee had a motive to benefit the employer when he assaulted the victim. So this is a direct quote from that Supreme Court case. It is possible to hypothesize how such acts could occur while the employee was in fact performing a specific job-related service for the employer, and while the employee was actively engaged in job-related services. Martin's here, that's the individual assaulter, the individual employee, just the horrible person that's sexually assaulting the victim here. Martin's job-related services included undressing the residents, changing their undergarments and diapers, as well as bathing them. If Martin's acts of molestation occurred simultaneously with his performance in these job-related services, a reasonable jury could infer that he acted from a mixed motive and not wholly from some external, independent, personal motive. So obviously I've summarized a very small portion of the case. There's a lot more parts of the case that if you're interested, I would recommend going and reading the whole case. But what this court did here was essentially said, the trial court needs to develop more facts to determine what the actual motive of the defendant was there. And if there was a mixed motive, then the meaning partially to benefit him for his sexual deviance, but also partially in the course of the job to do the job, then the jury could find for the victim. So to be clear, the Supreme Court didn't outright say that the victim loses. It just said that the facts needed to be established so the trial court could make that analysis, and then on appeal, the appellate court could decide whether or not that was decided right under the law. So it's a bit of a complicated way to say that, but when I first heard about Our Lady, Our Peace, when I heard about it initially, I was thinking that that it was an outright loss for victims of sexual assault, and it essentially foreclosed the ability to go after an employer for sexual assault. But I will be honest, as I read the case more deeply, I didn't see it so black and white. I did think that the court allowed some room to, as a victim, to allege facts that there's a mixed motive, therefore there should be vicarious liability. So I didn't think that Our Lady of Peace ended the ability for victims to go after employers of sexually assaulting employees. I think it narrowed it, and I think it changed what previous to this case we all thought from the plaintiff's bar about when you could hold an employer liable, but it definitely narrowed it. So we then come next to a case from the Court of Appeals, HC Hospital versus Potomac Hospital. And this is just a case citation, 81 VA App 1, 2024. What that means, 2024, is the year it's decided. This is the reporter where you can find it. Technically, it's on now all online, but where you used to be able to find the book. But VA App means Court of Appeals. So in Virginia, there are three levels of trials from a basic standpoint. You have the trial court. The circuit court is the court of record. That's what you see on the movies with the judge and the jury. You then have the Court of Appeals, and then if you lose it, you can go up to the Supreme Court. Now, I wanted to say that there was a significant change in the way that Court of Appeals and Virginia appellate courts operated in Virginia in 2019 that changed in 2024. And I'm not exactly sure the year changed, but we had an extensive expansion of our Court of Appeals here in Virginia, essentially the first level of appellate court. Before this, all civil cases would traditionally go directly up to the Supreme Court of Virginia. So that's the reason you have Our Lady of Peace coming from the Supreme Court of Virginia, because you didn't really have a whole lot of avenues to get to the Court of Appeals. That was more really for criminal defense cases to give them more opportunities. And I think family law cases went to Court of Appeals as well. Since then, and I want to say the year was 2021, we expanded the Court of Appeals to where all civil cases now go to the Court of Appeals, and then you can also go to the Supreme Court. So I think that's the reason this ended up in the Court of Appeals rather than going to the Supreme Court. But this case then really put a death knell to the ability to hold employers liable for sexual assaults of their employees. And again, I've provided a summary here. Virginia Court of Appeals found outright that an employer, a hospital, was not liable for the acts of its employees when he sexually assaulted a victim while she was inpatient. In that case, a patient was admitted to the defendant hospital when the employee, a floating nurse, sexually assaulted her. And just so you know, a floating nurse is somebody that's not really assigned a specific patient, but they're essentially taking overages and all on different stations and things like that. So that's a very general description of what a floating nurse is. But just imagine it's not your specific nurse when you go to the hospital, but somebody that's coming around and floating essentially. And just to go on, a patient was admitted to the defendant hospital when the employee, a floating nurse, sexually assaulted her. In supporting the case, the Court of Appeal found that the employee had already completed his work duties despite having assaulted the victim while she was still in her hospital bed, and that by obtaining the victim's telephone number, contrary to acceptable hospital practices, the evidence indicated that the employee was on his own mission rather than that of the employer. So let me break that down a little bit, because again, I summarized in this article the case. Again, I would suggest you go back and actually read the whole thing in detail. The individual was in the hospital admitted for having some health issues. I think it was related to an a virus, I think HIV actually, and so she was there for some complications arising to that. Apparently, this floating nurse came in. I think he was just supposed to change maybe her IV drip or something like that. He then did that, but as he's there, he then starts having conversations with her, making really inappropriate statements, commenting about how her body looked and things like that, and then ended up physically touching her inappropriately and sexually. And then at some point, I guess he actually asked for her phone number. I don't recall if the facts established that she actually gave it to him or not. But there, the Court of Appeals essentially said that, look, even though he was on the job, he was on the working hours, he was in the place of employment, he was in his, I presume, in his hospital gown, and I'm forgetting what it's called, in his scrubs. Because he was technically done with his technical part of the job, he's no longer within the course of employment, within the scope of employment. And then it went on to essentially be very specific, indicated that the employee was on his own mission rather than that of an employee. So now the law is essentially saying in a different way is, unless you are, ironically, unless you are doing the sexual assault for the benefit of the employer, you are not within your scope of employment. Therefore, the employee is not liable. And so unless the sexual assaulter is actually sexually assaulting on behalf of his employer, there is no liability on behalf of the employer. And I've been trying to think of a hypothetical when you would even have a case where an employee would be sexually assaulting somebody for the benefit of the employer. The only thing I can think about is what's been in the news recently is Jeffrey Epstein hiring, I guess you would consider Ghislaine Maxwell his employee, sort of, and then sexually assaulting somebody for the benefit of Jeffrey Epstein. That's really the only hypothetical I think where it would even be feasible. And the reason I bring that up is just to show how kind of absurd that standard would be. There's no way you're ever going to meet that. Okay. And so what that effectively meant under this statute or under this case law is, if, let's say, you called me as a sexual assault victim, unless I could establish that the person that sexually assaulted you did it for their employer, I would have to say, look, it's going to be hard. It's going to be virtually impossible to hook the employer, and that person assaulted you is in jail. There's not a whole lot of money to get from them, so I can't really recommend going forward with it. Now, I just a quick caveat. There is also, I believe, a way, even prior to this new statute, and even with this case law, if you're able to establish that the employer separately knew that the employee was a danger, I think that's a separate claim of negligent retention or negligent hiring, meaning you were aware, or at some point you became aware that this person was a danger to the community, yet you kept them on. So that's separate and apart. That's not what we're talking about in these sets of cases. These sets of cases is assuming the employer didn't know that the employee actually had done this before, or there was concern. So in those other cases, I think there's still the ability to claim for negligent hiring or negligent retention because you knew you had a dangerous employee. But what I'm saying is, under this statute, essentially immunize them unless that employee was literally doing it to help them, which, again, when would that ever happen? And so what that did is really narrowed the ability for victims to have any civil recourse. And but fortunately, again, Virginia law changes, and sometimes it changes in very positive ways. And our General Assembly sought to take action, and I believe it was specifically in direct response to these lines of cases. And so they created a new statute. And so that is, and let me just bring this up so you can see a little better. Virginia Code Section 8.01-42.6, Liability of Employer for Personal Injury or Wrongful Death Act. And so when we talk about personal injury, it can be any other that's a broader statement than sexual assault, but the crux of what the statute was seeking to fix is sexual assault. So, just getting directly to the statute again. Um, in addition to any other available grounds, interpretation of the course and scope of employment in an action for personal injury or death brought by a vulnerable victim. So, just to be clear, the statute meant to add on to other avenues to go after employers. So, again, as I was saying, negligent retention, all that kind of stuff. This does not limit that. This does not mean this is the only way to go. Even if we're thinking about like a car accident case, and somebody's just driving and causes a crash, this statute doesn't in any way limit that. It's just meant to add an avenue for specific vulnerable victims. So, in an action for a personal injury brought by a vulnerable victim or the personal representative, meaning somebody passed away, so they're a representative, the fact finder at trial on the merits shall determine whether employer shall be vicariously liable for the tortious conduct of such employees based upon the finding that. So essentially, the Court of Appeals, the General Assembly has set the analysis now on when somebody's vicariously liable upon these conditions, okay? And it's talking about vulnerable victims. So first of all, let's talk about what it means to be vulnerable victims, and then we'll get to when is their vicarious liability. And here, the statute specifically contemplates who is a vulnerable victim. So it's down here, subsection B, means any person who is substantially disadvantaged relative to the employee due to circumstances, including such person's physical or mental conditions or characterizations, as a matter, and it goes on to say, as a matter of law, shall include a patient of a healthcare provider, and it has definition of healthcare provider, a person under disability, and again, it has another statute, resident of assisted living facility. So we're talking about Our Lady, Our Peace, passenger of a common carrier. So we're talking about, bus riders, taxi riders. Now, it does specifically exclude services under the Washington WMATA, essentially. And then passenger of common carrier, excluding public transit. So I guess it's trying to protect the public transit. Passengers of non-emergency medical transportation carrier. So, think ambulance that's giving you a ride that's not an urgent situation, I would think. But again, it's here. I'm not going to get into the details of that definition here. You can click on that. A business invitee of aesthetic spa or a business offering massage therapy. So as you can see there, it is specifically addressing specific businesses. So massage therapists, assisted living facilities. I think even, if you're a patient at a hospital, I think that probably would apply there. And another caveat I will say, the way that statutes work is the legislature writes them, they provide the words, and they do the best they can to define them. But inevitably, there is going to be ambiguity in statutes to pass, especially something that that is this fresh. Okay, as I'm videoing this video, it is August 5th of 2025. This statute came into effect July 1 of 2025. So typically, what will happen is a statute gets passed. It comes to relevance in active cases, and then there's litigation on those cases. There's disagreements, and then there's appeals on those cases. And then you have trial courts, you have appellate courts, and then you have the Supreme Court ruling on what these statutes mean. So, what is whether or not a nursing home counts? Well, it says here, assisted living. Does a nursing home count? Maybe. I don't know. And I would think so. But again, there will be ultimately written opinions. I'm sure those things are going to be litigated here as defendants are going to try to defend themselves, as businesses are going to try to defend themselves. But I think the legislature did a pretty good job in laying out a definition of vulnerable victim. But again, there's definitely going to be more court cases that are going to define this in more totality. So that's how it addresses vulnerable victims. So again, just going up here in actions for personal injury, wrongful death by a vulnerable victim. Okay. Now the second prong is employer shall be vicariously liable for the employee's actions upon a finding of, and then it has these four conditions. And just to be clear, after 3, you have an and. So what does that mean? That means all 4 conditions must be met. If this was a or, it would mean any of these conditions could be met. So when you're looking at this case, when you're thinking about this statute, and just to be clear, also, this is not legal advice. This video is not legal advice. This is for information purposes only. If you have a case and you want to know, are you going to meet the statute's requirements? Feel free to call us. We'll give you a consult on the specific facts of your case, give you legal advice. This is not legal advice. You can't rely on this as legal advice. This is me helping highlight a statute, giving a few bits of information. But like any type of case, you have to get advice on the specific facts of your own case. You can't rely on YouTube videos, can't rely on Chat GPT, all that stuff. You got to talk to an attorney to get specific advice. Or if you want to train yourself, that's fine, but you got to rely on your own analysis. So, but again, because all four needs to be met. So when will an employer when will they be considered vicariously liable? So number one, the Employees Tortious Act conduct occurred while the employer was reasonably likely to be in contact with a vulnerable victim, and such proximity conduct proximately causes the personal injury to such a vulnerable victim. So what does that mean? Thinking back at that HC versus Potomac Health case, that means the floating nurse was employed there. He was around patients, and I think that clearly applies for purposes of how to define somebody as a vulnerable victim. Apologies, my light just went off. So that's number one. You're essentially talking about places of employment where you know that you're putting people in danger's way. Okay, number two, employer failed to exercise reasonable care to prevent the employee from intentionally harming such a vulnerable victim, or control the employee, resulting in unreasonable risk of a vulnerable victim suffering from such personal injury. So what does that mean? That means that the employer was, essentially careless and negligent in considering what steps they need to take to make sure these things don't happen. Again, these issues are going to be litigated. I could also see situations where you would need an expert witness to tell us what are reasonable efforts that an employer should have been making in a certain setting. So in a massage therapist office, I could see an expert being useful to talk about, well, what steps could have been taken to make sure that the employee wasn't in a position to sexually assault the customer. So, for instance, maybe there's a scenario where you should have two employees in a room to make sure that the victim is not vulnerable. Maybe you should have cameras potentially. Again, I'm just thinking it through. Maybe you should have appropriate training as to what they should and shouldn't do. Maybe there should be, at least if it's not video, audio recording, so that that you can hear what's going on, even if you can't see it. Maybe there should be education for and I'm just thinking this out loud. Maybe there should be education for the customers. For instance, I'm just thinking about this out loud. Maybe employers would be smart, massage therapists would be smart to list on a customer rights on the wall. A poster says, look, the employee is not supposed to be doing X, Y, and Z. So for instance, in a massage therapist office, it is not acceptable for an employer to ask you to remove your shirt. It is not acceptable for an employee to touch your chest area. It is not appropriate for the employee to be asking you about sensitive topics, things like that. As I'm just thinking out loud what that could mean. But again, the statute has not yet been litigated, so we don't know exactly what that means. Again, I'm just thinking out loud. So let's go on to prong 3. The employer should have known the ability to control the employee. I think in a lot of ways it's related to what we just talked about. Like I said, if the reasonable standard is to put a warning up on the wall for the customer to know what's acceptable or not, the employer should have known how easy that would have been to do. And so, again, I'm just really speculating as to what that exactly means. Obviously, every case is going to be very different. The facts of every case is going to be very different, but this is a prong that the courts will be looking at, and your attorney, if you're bringing a case, should be looking at to get a better sense of, well, how do we prove that prong? And then let's go on to the fourth one. The employer should have known of the necessity and opportunity for exercising such control over the employee. So I think here, again, it doesn't lay out exactly what that means. Maybe there'll be expert testimony, but I can just keep on thinking about where in my practice do I keep seeing these things come up? Massage therapist office, physical therapy locations, assisted living facilities, places where your individuals are having physical limitations or cognitive limitations that make them vulnerable. So if an employer knows that it's a risk or should have known, then I think it meets that prong. Again, how we will prove that ultimately when we litigate these cases, again, it may be an expert required. It may be that, it's kind of common sense. It may be that you use that prior acts have happened there before, and you find out that people have been sexually assaulted there before, so they should have known. That could be another alternative. Again, I'm just speculating as I'm looking at this now. But that being said, again, those are the four prongs. Now, what do I think about this statute? Again, I am happy that the legislature showed initiative in taking this technical issue up. Far too often, I get the pushback, especially in my civil practice, that any plaintiff's lawyer is an ambulance chaser, and there's too many frivolous lawsuits, and people make things up. Fortunately, in this area where you see victims of sexual assault, I'm glad that the legislature took this seriously and didn't just push off, the complaints. I can tell you, again, I wasn't personally involved in seeing it through, but I suspect that there was a lot of business lobbyists, small business lobbyists, saying that this is going to be the end of our business. It's going to end the ability for us to hire employers. And if we have customers on site, we're never going to be able to pay for insurance premiums, things like that. And when it comes to business lobbying and insurance lobbying, they have a lot of money behind them. So it takes a strong legislature to stand up for victims. So I'm glad that this happened. Now, do I wish that the statute made it a little bit clearer and easier to prove the case? As a plaintiff's attorney, sure, absolutely. I could think of ways to improve the statute, and I know ways were discussed, but with any statute, there is give and take as you're trying to work with the other side to get things passed. So I think this version of the statute is good. Could have been better, but what is it? Perfection cannot be the enemy of good when you're talking about progress. So I'm glad that this was passed. I think that it definitely leaves avenues for potentially victims to seek recourse civilly, and I'm glad. If you have any questions about this, or if you have a case, obviously feel free to reach out to us at Abrinio Law. If you're interested in Virginia law and policy, make sure to like and subscribe. If you found this useful, feel free to share it with folks that you think need it. And we're just trying to make sure that we get the word out, because I think this is a great advancement in Virginia law. And I think, I always tell folks, I hope to never have to work with you. I hope that you don't need to know about this, because if you do, either you or a friend or family member has been severely injured, traumatized, your life seriously altered. So I'm sorry if you need to know this information, but I'm also glad that at least you're educating yourself, whether it's with this information, the statutes directly, talking to other attorneys, talking to me. You have a right to be heard. And, if you call me, I can't guarantee that you're going to have a case. But what I can guarantee you is I'll give you my honest opinion, and whether you like it or not. So at least you know what I'm sincerely thinking. So I wish you the best. Take care, and keep